Good afternoon, everyone. I'm going to give people just a minute to join, and then we'll go ahead and get started. All right, for the interest of time, I'm going to go ahead and get the webinar kicked off. I'm certain that more people will hop on as they can. Welcome to Chesapeake Legal Alliance's Sackett versus EPA. What does this case mean for the Chesapeake Bay and watershed? But before we get into the meat of the presentation today, I want to tell you a little bit about CLA. Evan, would you go ahead and thank you. We are a small nonprofit based in Annapolis, Maryland, and we offer pro bono legal services to people and organizations throughout the Chesapeake Bay watershed in the furtherance of a healthier bay and healthier local water quality. We do this in a number of different ways. We offer these services through our Legal Education Center, which is how we are offering this webinar today. The Legal Education Center offers community-led legal education. We offer services like webinars, we do presentations, we offer neutral, objective information about what the law is and how you can use it in your own community to further your local water quality. We also provide pro bono legal services through our Environmental Action Center. Our Environmental Action Center is where we offer litigation services, we offer research and analysis services, we provide innovative solutions to what your legal needs are on the ground. And we also have an outreach center at CLA. Our outreach center is how we work with a network of pro bono volunteers who really bolster the services that CLA is able to provide. And we also work with law schools and law students to provide those same types of services. So with that, I'm going to tell you a little bit about who's sitting around at the table today. We have David Reed, who is CLA's executive director. We have Evan Isaacson, who's a senior attorney and a director of our Environmental Advocacy Center. And then my name is Molly Brown, and I'm a senior attorney, and I direct our education center at CLA. So before I hand it over to Evan to get to the substance of today, I just want to tell you a little bit about the nuts and bolts of the conversation. The three of us are sitting around the table. All of us are here. We're going to try to keep it as informal as possible. This is a weedy subject, and we are going to do our best to not speak in legalese. If we are using acronyms, please call us out on it. If you have questions as we go, please enter those questions into the question and answer section. I know that many of you sent in questions prior to the webinar, and we've done our best to incorporate the answers into those questions into the slides that are coming up. But if you have questions, new questions as they come, or you're not clear on what it is, please go ahead, enter those questions into the question box, and we're going to leave some time at the end to be able to get to them. If we don't have time to get to your questions during the webinar, then we will make sure to reach out to you afterwards to help follow up on those answers. The webinar is being recorded, so we will send that out to registrants after the fact. So if you know people who are unable to attend today's session, they will be able to watch that after the fact. And with that, I think I'm going to hand it over to Evan.
All right, thank you, Molly.
You're welcome.
So as Molly indicated, we asked a few weeks ago for folks to send in a list of questions, and I attempted to answer as many questions as I could through this presentation. So it really is tailored to what you asked. And I think, for the most part, people want to know what this means for the Chesapeake Bay, for their local waterways. Nobody asked about the case itself. And I'm not going to brief this like I would for a bunch of lawyers. We will not be doing the legal play-by-play or talking about the procedural history, who the Sacketts are, their particular property, or the reasoning from the court. I'm going to stick to the big picture background, just enough to actually explain what was at stake today, and then we'll go straight into implications. Try and make this action-oriented. As Molly said, feel free to pose additional questions beyond what was sent in already, and we'll do our best to answer them. If we don't answer anything, we will certainly get you an emailed answer in the next week. All right, so waters of the Chesapeake Bay. This image I've never used before in a presentation. I think it's illustrative of, or symbolic at least, of a couple of things. One, this is not clipped to the Chesapeake Bay boundary, 64,000 square mile watershed boundary. This is coterminous with the state boundaries. This is a national decision that has national implications, and the states are going to be not just thinking about the Bay when they make decisions about what to do post Sackett. They're going to have to be thinking about their entire states. Two, this looks like a big blue blob to some of you, and that's because there's water everywhere. This is a high resolution map representation of all surface waters, wetlands, streams, etc., from the federal government. So it just goes to show how much of our landscape is covered in water. All right, so for starters, let's just talk about the Clean Water Act, a little bit about the Clean Water Act. I think for many of you on this webinar, for most people thinking about the Clean Water Act, certainly here in the Chesapeake Bay region with the Bay TMDL restoration effort, and TMDL is total maximum daily load, but just think the restoration effort of the Chesapeake Bay. We think of what's called the Section 402 of the Clean Water Act. That's the water pollution prevention law. Some people refer to it as NPDES or NPDES. That is all about how to prevent pollution. Think of factories and sewage treatment plants discharging into rivers and the ocean. The other major program, though, is the 404 program, which a lot of people refer to as the wetlands program. It's a misnomer. It's not just because I'm a nitpicky lawyer, but 404 regulates activities, dredging and filling, not a particular type of water, wetlands. In fact, more 404 applications are for dredging and filling near headwater streams than they are wetlands. The Sackett decision primarily was directed at Section 404, not 402, but it will have implications for both programs. And I'll be talking about that ahead. So when Congress wrote the Clean Water Act, they didn't have one set of definitions for 404 and one for 402. They didn't have one statutory purpose for 404 and another one for 402. For better or worse, they tethered those two together under one law with one purpose, one set of definitions. And that's why we have a very complicated legal decision handed down to us, because what they did to the 404 program will have dramatic implications for 402, for everything from a point source discharge from a factory to your TMDL restoration efforts. It really goes well beyond just a wetlands decision. And then finally, it's critically important to understand the Clean Water Act goal. It's something that was not lost in the Supreme Court when they were making earlier decisions in Clean Water Act cases, including wetlands cases, but it is something that was clearly lost on the Supreme Court in this decision. The goal is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Congress was not interested in floating boats, but restoring water quality. Again, this was something that appeared lost on the majority of the court in this decision. So are we really arguing about definitions again in the Supreme Court, and why? Well, yes, we are. And most major environmental decisions, they come down every few years. They're talking about a particular statutory or regulatory provision or program, and the environmental standards or levels of protection that flow from that provision or program. In this case, and in a minority of cases, we're talking about jurisdictional questions. What are the bounds, the outer bounds of that statute, in this case, the Clean Water Act? That's what Sackett involved, was the jurisdictional question, physically, literally, geographically, where does the Clean Water Act and federal jurisdiction begin and end? And beyond that, where does the state law kick in? For the 404 program, the Dredge and Fill program, most of the major Supreme Court cases have been about jurisdiction. The 402 program, the Supreme Court doesn't have quite the antipathy for that as they do for 404. And the reason is it's not just industries on the other side of the Clean Water Act here. In 404, what's implicated is this sort of ideological concern about the federal government overreaching into local land use and planning decisions. Developers want to be able to fill a wetlands to build the development, and those property rights concerns are often what are at play in these Clean Water Act decisions. And so jurisdiction is all about definitions. In this case, it's a water of the United States, a WOTUS. That is part of the jurisdictional bounds, and that's what the Supreme Court was arguing over. I do want to emphasize, though, that the water of the United States is not solely and specifically what defines whether or not clean water jurisdiction exists. There's a number of factors, and all of these terms, maybe surprisingly, maybe not surprisingly, have been litigated pretty heavily. Water of the United States is just one of them, but as I'll explain in a few minutes, the fifth one there you see, from a point source, was also the source of a very major Supreme Court decision just a few years ago that went well for the environment. And that may have some implications here going forward. So just to note that WOTUS is not the sole determinant, water of the United States is not the sole determinant of whether or not there's federal jurisdiction under the Clean Water Act. Here's a nice map of one of our base states, Pennsylvania. I'm a visual person. I think many people are. It's helpful to see this. There are those yellow shaded areas. Those are actually little buffers around what are called intermittent streams. So those are streams that don't have water at all times. This is just one example for you visual folks out there of how much jurisdiction was lost, how much jurisdiction under the Clean Water Act shrunk post Sackett. This map is incomplete. You'll notice some artificial squares in the middle where there's no yellow. That's just a function of mapping that was done at the time. But you can see that just how many of our streams are sort of headwater streams. You'll hear me say intermittent, ephemeral headwater. Those are the tiny first order streams that don't always have continuous flow of water, which apparently is important to the Supreme Court. Here's another map that zooms way in using that same data, color coded. You can see some of the blue sort of main stem rivers and streams. Those will not lose jurisdiction under Sackett. But you can see some of the shaded red is intermittent and ephemeral. The green are ditches. I'm not actually sure. I think this is somewhere in the Delmarva Peninsula, but in agricultural areas, there's a lot of ditches. It just goes to show that there are maps out there that can help. I know a lot of people sent in questions asking about a particular location. I can point you to some resources to where you can sort of zoom in and see your own local areas and what those waters look like. But you can do even better than that. You can make customized maps based on topography. This is an elevation map with the lighter shaded gray or higher areas. The black is actually negative. And it's an overlay with, you can see blue is just, perennial streams, perennial rivers where you can float a boat, float a kayak, that the Supreme Court left unchanged. Green are tidal wetlands. That's where things start to get a little murky. And then you can see all those yellow. I highlighted in yellow, those are wetlands that will lose protection, federal protection.
Evan, may I interrupt you for a second? We had a question come in. Would you be a little bit more specific about what jurisdiction of the Clean Water Act means?
Sure, that's a good question. So the Clean Water Act regulates all kinds of activities, and it also provides all of us with certain rights. If there is no federal jurisdiction, over a particular area, that means in that area, when there's dredging and filling, there's no federal oversight, there's no ability of the public to intervene. If there's a factory that wants to locate and start discharging to, say, an ephemeral stream, it doesn't happen often, but if they wanted to do that, they could, in theory, attempt to do that outside of the bounds of the Clean Water Act and all of the regulatory oversight that comes with it, all the public rights that come with it. And then it just varies among the 50 states as to what happens next. In some states, there's a robust regulatory program, and I'll get into that in a minute. In other states, there's nothing, literally nothing, and nothing stopping dredging and filling, discharging of pollution. There's no laws that will be applicable to that pollution.
So when we're talking about the jurisdiction of the Clean Water Act, we're talking about what waters and areas this federal law, the Clean Water Act, applies to.
That's correct.
Okay.
Yep. And you can see that in visual form here on this map. Again, it's a little bit hard to understand, but I'm walking you through it. So the light blue streams are our first order streams, and these ones are intermittent and ephemeral. They lost protection. They used to not lose protection under the previous definition. They would have been federally regulated. You couldn't dredge and fill into those streams. You couldn't dump pollution in those streams without a permit, without federal oversight, without us as the public having federal rights. And you can see that in some of those zoomed in area, if I could zoom in, some of those black little streams are not even mapped, but those are channels, right? They weren't carved by aliens, they were carved by water. You know, those are further unmapped, ephemeral, intermittent streams that, you know, before may have not even had federal jurisdiction. That would just depend on the state. But you can see how complicated hydrology is, and the Supreme Court, unfortunately, indicated they have no interest whatsoever in hydrology, and solely wanted to turn back the clock from a purely legal perspective and talk about where you can float a boat. And all those yellow wetlands that are highlighted in there, they certainly have no federal protection anymore. All right, so just very briefly, some background here. I'm not going to go into the cases, but just to illustrate that the 404 program has been before the Supreme Court several times before over the decades, including 1985's Riverside Bayview Homes case, which went in the exact opposite direction. It was unanimous in favor of an expansive and purpose-driven view of the Clean Water Act. Can skip ahead to Rapanos. I was in law school when this decision came out. I remember it being a very big deal. And it was a split decision, 4-4-1. And the swing vote, Justice Kennedy, got to basically write the standard that has existed for the past 17 years, the significant nexus standard, which was a science-based approach to where federal jurisdiction belongs. The 4+ Kennedy created essentially the controlling standard, the significant nexus test that has now been overturned. The other 4 are essentially what Sackett adopted here in 2023. That other 4 was written by, the opinion of those other 4 was written by Justice Scalia. And like I said, the current Supreme Court essentially has adopted Scalia's interpretation of where Clean Water Act jurisdiction should begin and end. The Supreme Court's Rapanos decision, like I said, created that significant nexus test, and that basically said, I quoted it there, wetlands either alone or in combination with similarly situated lands in the region significantly affect the chemical, physical, and biological integrity. So those are waters and lands that are under or were under the significant nexus test under Clean Water Act jurisdiction. And that is what was essentially reversed in Sackett this month. Next slide. So here's the Sackett's property. Google Maps has already labeled a historic landmark. You can see the lake there right next to their property. And just to the north or northwest is a very large wetlands complex. But you don't need to take my word for it. Here's the actual topographic map showing a continuous connection of wetlands from several hundred feet north of their property all the way down to the lake.
What state are we in?
This is Idaho. Apologies. And there's a stream running right through it. So, you know, if you were to walk out there, would you get wet? Yes. Yes, you would. There's water there. Really briefly on the decision, we have 5 votes, like I said, adopting the Rapanos orality written by Justice Scalia. And it takes the Clean Water Act back to a place it hasn't been since the 1970s, only briefly. We had 4 votes in the minority here. It was the 3 justices appointed by Democratic presidents, plus Justice Kavanaugh, appointed by President Trump. And they would have sort of adopted the pragmatic, purpose-driven interpretation that's existed for 4 decades. And we had 2 votes, Justice Thomas and Gorsuch, who basically adopted what I would call the worst case scenario. It's something we learned about in law school 20 years ago in both constitutional law and in our environmental law classes, that the Constitution, according to some interpretations, does not basically allow for federal environmental law at all. There's no constitutional basis for those. What Congress said was that when they wrote the Clean Water Act, the Clean Air Act, and a lot of these other environmental laws, they were writing it to be basically governed under the Constitution's Commerce Clause provision. And what that means is, because it affects interstate commerce, you can have a federal environmental law. Justice Thomas and Gorsuch take a very different approach to that, saying any environmental law that's based on the Commerce Clause needs to be specifically and solely focused on interstate commerce. So to them, that's why not only would Clean Water Act jurisdiction only apply to waters that are navigable, arguably they would only apply to anything that actually impedes that navigation. It's a very antiquated view, and it's the worst case scenario, because if we had 3 more justices that adopted that, we would not have a Clean Water Act either at all or in anywhere near its current form. It would be deemed unconstitutional. Then we have 2 of the 6 votes from a decision just 3 years ago that in this case split. You had, in that case, County of Maui, what it said was, if you have a point source of pollution that stops just short of a navigable waterway, in that case, it was an underground pipe that went down 2,500 feet, actually several hundred feet, sorry, but 2,500 feet from the Pacific Ocean, and then started dumping its pollution. The Supreme Court in that case said that's the same thing as a discharge to the Pacific Ocean. It's the functional equivalent, right? And that was a very good result. In that case, Justice Roberts joined the majority and basically said, yes, you do have Clean Water Act jurisdiction, even though it doesn't actually reach that navigable waterway. And we have Justice Roberts in this case joining, unfortunately, the majority that strips a lot of Clean Water Act jurisdiction. So that was Roberts, and then Kavanaugh split with Roberts in this case, and he went the other side with the minority. And I will talk a little bit more about what that County of Maui decision means in a few minutes. So that's where the justices were in that case. So we're going to start wading our way into some of the implications here.
Before we do, may I ask you a couple of questions, which I think that I know that you don't want to get bogged down in this, but what did the Sacketts want to do?
They wanted to fill the wetlands.
To do what?
They did fill wetlands to build a house.
Okay, so they were looking to build a private residential property. They wanted to fill wetlands. They were arguing that the Clean Water Act didn't apply to the wetlands that they were trying to fill.
Correct.
Okay.
Yeah.
Thanks.
Okay, so the significant nexus test that existed. So when you were trying to figure out this wetland or that stream, is there federal jurisdiction over that? Prior to the Sackett decision, we had the significant nexus test. And so you'd have someone go out into the field and apply that test. Is there a very direct hydrological connection between that wetland and that waterway that's clearly jurisdictional? And if so, you need a federal permit. It doesn't say you can't build there, you just need a permit. And so that's now out in the current world we live in. So that's being replaced by jurisdiction is no longer driven by that sort of determination, that scientific, science-based determination as to whether there's a hydrological connection. Instead, you have jurisdiction only over, quote, relatively permanent streams, oceans, rivers, and lakes. And this is where things start to get sort of muddy. They use the term indistinguishable. You only have jurisdiction over wetlands, Clean Water Act jurisdiction, if it's indistinguishable from those other clearly jurisdictional water bodies. So let's try and break that down and figure out what that means. If you are riding your kayak around your favorite water body, that water body below you is still jurisdictional under the Clean Water Act. Someone can't just start dumping pollution into it. If you reach your paddle out 3 feet to your right to touch some wetlands, we think that's probably still covered. If it's, quote, indistinguishable, right? So if the water is clearly flowing into that wetland, there's a bunch of reeds and grass flowing above the water, but there's clearly water below those reeds. It's probably still covered, but it's hard to know because, again, this is not a science-based decision. It was a legal decision, and the justices clearly just didn't want to wade into sort of how the wetlands hydrology matter to that navigable waterway. They just wanted to talk about navigation. Can you navigate into a wetland? I don't know. So wetlands outside of the reach of your paddle. If you're reaching outside of your kayak and you can't touch the wetland that you can clearly see a few feet away, may not be covered anymore, right? It's got to be indistinguishable from the water body itself that's covered to have federal Clean Water Act protection. And then creeks that dry up sometimes. They used to be covered under the significant nexus test. There's clearly a significant nexus over that creek just because it's dry. It's likely not covered anymore. The Supreme Court did briefly touch on they said relatively permanent streams. So they did touch on, well, what happens when the tides are low? What happens when we're going through a major dry spell? A stream or river that is almost always covered in water that occasionally is not, they basically said that's probably still covered. But creeks that regularly dry up, not covered anymore. That's an ephemeral or intermittent headwater stream, and those no longer have Clean Water Act protection. Why is this important? Because most of our streams are headwater. Most of the analyses conducted by the Army Corps, EPA, or academics, they have found that majority, in some cases, in most regions, the vast majority of our stream miles are headwater streams. And those lost federal protection. So implications, geography matters, hydrology matters a lot. So here in the Chesapeake Bay, we are not dealing with a landscape that's vastly different than, compared to the West. Every state, in every region, in every area, there's no question that the Sackett decision will have an impact, but it will vary dramatically based on where you are in the United States. And in the West, the estimates nationwide vary between 50 and 75% of water lost Clean Water Act protection. No one has an exact number because no one knows what to make of the decision. But there's also some mapping difficulties, but more than half is what most of the analyses have said will lose Clean Water Act protection. Jumping down to the bottom there, you can see that as little as 18% of the stream miles in Nevada have continuous flow, as much as 78% in Florida do. The Bay States, it's roughly around 55%, plus or minus 2 or 3%. They're all very similar based on our climate and hydrology. Isolated wetlands and seasonal or intermittent streams are everywhere. But remember, 404 is not just a wetlands program. It governs those waterways as well, every bit as much as it does wetlands. So the impact on jurisdictional determinations, that's the term for the determinations by the Army Corps or other officials when they go out to determine whether or not a waterway needs a permit to be disturbed. There's going to be a dramatic impact on those immediately. And the EPA analysis of the Trump WOTUS rule from a few years ago really gives us a good preview of what the future will hold for us, because EPA had to do a regulatory analysis to implement that rule. And it found that prior to 2015, for most of his 404 history, 45% of jurisdictional determinations resulted in the finding that no permit was needed. Under the 2020 rule, their estimate was that 75% of jurisdictional determinations would not result in needing a permit. So that's a 40% reduction according to that EPA analysis, which again, the 2020 rule is roughly consistent with what the Supreme Court's majority held in Sackett. So here's just those maps again. We already went over them, but just a refresher, some of those red headwater streams are just a visual representation of the types of water bodies that will lose federal protection. And again, there's that map I showed earlier. Some of those isolated wetlands, some of those headwater streams, even some of those green, clearly tidally influenced streams. This is a map of Annapolis area. Even some of those green areas will lose protection potentially if those are covered by wetland vegetation that are so thick that you can't see the water. I mean, it's really hard to understand what the Supreme Court's thinking, but it seems like if it's not navigable, it may not be federally protected anymore. This is a really interesting mashup I made. So blue is just the water bodies. It's all surface water. All right. So it's rivers, streams, creeks, headwaters, wetlands, all of it. The green areas, the green shading is a map from researchers at University of Massachusetts who put together what they're calling the Ecological Integrity Index. It basically measures habitat quality. And the darker the green, the higher the score, lighter the green, the lower the score. White basically means it's devoid of suitable habitat for biodiversity. And what I wanted to show here is you can see just how closely related the blue and the green are, right? Where you have areas of high ecological habitat, of high quality habitat and ecology, you have water. They're inextricably linked, right? So partly that's a function of the fact that the 404 program was working. It was protecting these areas from being dredged and filled. And partly it's just a function of the fact that water is essential to our ecosystem. So this map kind of illustrates what we could be losing here.
Evan, we had a question come in that is applicable to what you just said.
Okay.
What will happen when filling begins to occur? And then that test of, quote, can your paddle touch wetlands means that where it previously could, it no longer can, because the boundary of the wetland has been changed due to humans filling it in. So this is a constantly moving target. It
is, and it lost its science-based approach. Right. So if you have someone out in the field trying to make a jurisdictional determination, they're trying to interpret what 9 lawyers thought, or even, I guess, 5 lawyers thought, rather than actually applying what they were trained to do their whole lives, which is measure hydrological connectivity. It's the Wild West. I mean, and we have to wait and see how EPA reacts. They have to rewrite their regulations. It's going to vary by region and by state. They have different regions of the Army Corps. They go out and make these determinations. It's hard to say. Can you speak a little bit to how that works? Because we've heard you use a lot of subjective words in describing what this new rule is out of the Supreme Court. So, intermittent, what does that mean? Regularly versus regularly flowing, or, an unusually dry season. Who gets to determine what an unusually dry season is? How are we going to know? I mean, everybody's putting themselves in the position of having to guess what the Supreme Court means. There's certainly going to be more litigation. I'll go into that in a few slides, but it's going to have to be fleshed out by EPA and Army Corps rules. It's going to have to be, case-by-case determination still, but there's going to be a lot of guesswork, and there's going to be a lot more litigation to sort of refine that. But, it is still case-by-case. Supreme Court basically made it sound as if even if you are have an adjacent wetlands to a river, a clearly navigable major river, even if it's adjacent, it may be covered or it may not be. It has to be, quote, indistinguishable. At what point does that waterway become indistinguishable? I don't know. And it's going to be left to the folks out in the field to make that determination. It's not clear. And it's something that EPA is going to have to be racking its brains to figure out. I hope that the right EPA administration gets to take a crack at refining it rather than the other sort of administration. Are there any other questions you want me to address now, or do you want me to keep rolling?
There's a lot, keep rolling, and
Alright.
I'll read through them and pepper them in.
All right, so state law also matters. When I mentioned that the West is going to be hit hardest, not just because of hydrology, it's because there's an awful lot of states out there who opted not to go beyond the federal Clean Water Act minimum, right? States under our federalist system can go above and beyond the federal minimum of the Clean Water Act, and Congress invited them to do so. Unfortunately, only about half of states accepted that invitation. Most of our Bay states, like in the second, have accepted that, have gone well beyond the federal minimum. A lot of the Western states chose not to. So not only do they have the wrong hydrology, they have the wrong set of laws. And that's where, you know, I guess, to use the pun, it's going to be the Wild West, and it's going to be really unfortunate for our Western waters. But a lot of Eastern states too are going to have some problems. And so, yeah, I do want to talk too about what this, it's not enough to merely have a definite definition for your waters of the state or waters of the Commonwealth, or a definition for wetlands that sort of expands beyond what the waters of the United States were, right? So if you have an expansive definition, it doesn't necessarily matter in theory where the geographic reach of the waters of the United States are, because the waters of the state go beyond it, right? So in those states that have a definition for a water of the state or a wetland, provide that additional protection, but that is not nearly enough, right? You could have a good looking statute, a good definition on paper, but you need a lot more than just that. You need an entire regulatory system to make use of those statutes and regulations. And you need enforcement, proper enforcement of those state laws and regulations. You know, even if you had both the definition and the statutes and regulations, and you had an agency set up to implement those, if you have an administration that comes in and says, we're just not going to implement or enforce, then all of a sudden you're basically, all of that has vanished, and you're still left with the vacuum, the post-Sackett vacuum, where federal jurisdiction receded and there's not much there left.
We have a question, what happens to JDs, which I'm assuming is jurisdictional determinations, in the meantime, while the Army Corps of Engineers and EPA figures this out? And then someone answered in the question and answer that the Army Corps of Engineers has stopped issuing the approved jurisdictional determinations while they're trying to figure this out. Is that, can you?
Dave, you want to take that?
Sure.
I don't know, to be honest.
Yeah, I mean, Wild West is appropriate, because if you step back and think about what this means, you know, a state like Maryland is particularly hurt, but if you look at the Florida Everglades that has 2 million acres of wetlands just in the Everglades system, and you think about what a dry spell means, well, a dry spell in Florida is technically, not just almost, 6 months. So if you have a determination of whether or not this wetland is in, well, it certainly is in for 6 months. So I think, you know, as Evan mentioned, it's gonna really matter how EPA responds to this, because they're going to need that guidance, unless it's just going to be great volume of litigation.
I mean, the Army Corps has been whipsawed back and forth with all of these different rule changes, right? There was the Obama era rule, and that was vacated. And then there was the Biden era, or I'm sorry, the Trump era rule, which was vacated. Now Biden's rule came out, and now that's being vacated. So it's been a whipsaw, and we've had this regional approach, right? Because different federal appellate courts will strike down the rule in their region, and then other regions it won't be. It's been a checkerboard approach for years now, so it's going to continue to be one. That's not a very nuanced answer to that question, but we can follow up by email.
Great.
And just one more detail about the jurisdictional determinations from the U.S. Army Corps of Engineers. They prefer to do it from a desktop, so they certainly need guidance, because they don't want to go in and look at wetland species and determine if the vegetation, where the ordinary high water mark is, if the vegetation is in fact what the new definition would resolve. So they're going to need that guidance.
Right. I mean, if you're out in the field trying to make a determination, you look at the soil, you look at the vegetation. There are clear markers from a biological perspective, from a physical perspective, of what a wetland is. again, the Supreme Court, lawyers, not scientists, and they decide to throw all of that out. And they just want to say, does it look like a stream? Does it look like a creek? Does it look like a river? So here's some of the Bay State laws in a table. This does not go into detail, but you can see, for example, just as the very basics, is there a definition for state waters? Or are there wetland laws? We're pretty good in this region compared to the rest of the United States, where it's 50-50 roughly. Maryland, New York, Pennsylvania, Virginia, West Virginia all have broad state definition of state waters. I note there in the footnote, basically at West Virginia, as I mentioned earlier, it's one thing to have a definition. It's another thing to actually have the comprehensive pollution control laws and the regulatory agencies to implement those laws. And I noted also that New York, I don't know if they did this in anticipation of what just happened. I should say right up front, nobody expected Sackett to go well for us. It was just a matter of how bad. And I think, I don't know if this was directly related to anticipating the Sackett decision or not, but they recently, just last year, strengthened their wetlands laws. So what's next? I'll fly through this. I don't want to get into the weeds or Molly will throw things at me, but just a few examples of sort of like the real weedy, nitty-gritty details. I mentioned that the court did not attempt to mitigate the damage to the 402 program, the NPDES program and PDES program when they issued this decision. Back in 2006, in the Rapanos case, Justice Scalia did address, to some extent, wanting to segment the opinion, his portion of the opinion, between 404 and 402, between the wetlands dredging and filling and the NPDES program. This case, they didn't do that. And so we're left with the assumption that a lot of, the problems that they created with shrinking Clean Water Act jurisdiction are applicable to both 404 and 402. So here's some examples of what that might mean. If you have a construction site, you have to have a NPDES permit, a 402 permit, because the construction site generates a lot of pollution, or it certainly can, if not properly dealt with under a permit. So whether you're dewatering from the construction site into an ephemeral stream, or whether you just have a construction site blowout of the sort that we see all the time, unfortunately, where's that mud flow going? Is that going into a headwater stream? More than likely. Is it going into a storm drain? Maybe. Is the dewatering happening into an ephemeral stream? Very likely. Those we don't know now. Does Clean Water Act jurisdiction apply? And here's where I'm going to loop in the County of Maui case. A few years ago in 2020. So what that case said, which was another jurisdictional case dealing with 402, not 404 program, it said, if you discharge directly into a water, we already know that's covered under the Clean Water Act. If you discharge just short of a navigable water, that's the functional equivalent, they said, of a direct discharge, right? So that's where that really good decision, that was a great case that came out for us. Justice Roberts, as I noted, joined the majority. It was a 6-3 decision, basically used a purpose-driven, science-based approach to determining Clean Water Act jurisdiction, and said, if you do that, if you dump that water just short of that navigable waterway, it's still a discharge. You still need a permit. And if you have a permit or violating it, you're subject to Clean Water Act liability. So that's where we have to wonder, as far as implications and what's next, will the Supreme Court revisit the County of Maui decision, or will they let that stand? And I mentioned that Justice Roberts earlier, I'm not saying this just to get in the weeds, but this is where that kind of speculative thinking about the justices' positions helps, because if Justice Roberts, who was on the wrong side of Sackett but the right side of County of Maui, sticks with it, and County of Maui stands, then that test, functional equivalence, could be helpful in determining how narrowly Clean Water Act jurisdiction shrinks. Because, and we now know under Sackett, an ephemeral stream is not jurisdictional per se, but if you're polluting an ephemeral stream, you're essentially putting pollution in a place where we know it will pollute a water of the United States. Under County of Maui, we would still have Clean Water Act jurisdiction over that. So it depends on what you're putting in a particular place. And again, it depends on what the Supreme Court does. Will they revisit County of Maui in the next few years and overturn it? Maybe. Will they strengthen and stick to it and do what Scalia suggested in 2006, which is you segment the 404 and 402 programs? Maybe. I don't want to be too in the weeds or speculative here, but I could envision some aggressive MS4 operators who don't like the fact that they have a Clean Water Act permit, wanting to say, okay, this outfall discharges to a pocket wetland or an ephemeral stream, more than likely, and we no longer think it's subject to our federal Clean Water Act permit.
Did you already explain what an MS4 operator was?
Municipal stormwater system. It's just the storm drain system. There's a lot of outfalls that discharge pollution, usually into perennial streams or rivers, but sometimes into intermittent ephemeral streams as well. And the question then is, for all those outfalls discharging to those ephemeral streams, are they now segmented off from the rest of the permitted MS4? We don't know. A warehouse complex, we're seeing a massive proliferation of warehouses all over the country. Part of EPA's, under the Biden administration's environmental justice strategy, was being able to exert Clean Water Act jurisdiction, what's called a RDA petition. They could exert permitting authority over that warehouse complex where it didn't used to exist, to make sure that the stormwater, the toxic runoff flowing from that complex that may be reaching a fence line community, they can make them get a permit and do something about that pollution. Well, now that becomes much more difficult if those warehouse complexes don't have any ephemeral streams nearby where it's discharging to, or a storm drain or a wetland. It becomes more difficult for EPA to sort of exert their permitting authority there.
Can you explain what a fence line community is?
Sure, it's the people who have to live right downstream of industrial pollution.
We had a question come in asking about the environmental justice implications of this decision. So I know that you just addressed one factor. Do you have other ideas about how this is going to affect environmental justice issues?
Yeah, I mean, I would give a whole presentation on that, but I mean, the bottom line is one of the foundational concerns of environmental justice originally was we want equal protection under the law. We want equal protection under the Clean Water Act. So whether that's enforcement and making sure that the laws curtailing illegal pollution are applied equally everywhere to all people, or whether it's in the permitting context and making sure that we're not permitting new polluters in that neighborhood, but not that one. The bottom line is we wanted more protections, more environmental protections that applied equally everywhere. So if you are reducing the overall scope of the Clean Water Act and its protections, you are necessarily harming more people. Will it be equal? Probably not, because we know that a lot of communities, because of redlining and other factors, are located, closer to those sources of pollution. So if you are curtailing the protections of the Clean Water Act, or similar thing happens in the Clean Air Act context or with other laws, you're necessarily reducing the amount of protections for all communities. And that has a disproportionate impact on environmental justice communities.
And right off the bat, the destruction of wetlands is, of course, going to exacerbate all of the issues we look at with some low-lying vulnerable communities, with flooding, with, storm surge, you name it. That might be an early wave.
How much time do we have?
10 minutes.
Let me see. All right. So what's next? I mentioned already, we're going to have a lot of litigation. How quickly this comes before the Supreme Court again, I don't know. Probably it's going to take a few years. Perhaps there's already cases winding their way through that they can address more quickly. But the lower courts will most certainly be hearing wetlands cases, certainly in the next few years, to try and refine what the lower courts think the Supreme Court meant, and that's going to vary by court. As I mentioned, the County of Maui decision could get revisited because, again, that's critical to preserving and protecting the 402 program. The functional equivalence standard that was handed down in the County of Maui decision really can help insulate the 402 program from the damage done by Sackett. But the question is, will the Supreme Court revisit that and overturn it? We do have new justices now since that decision only 3 years ago. At EPA, as I mentioned, they're going to have to be rewriting these regs and the guidance. The Army Corps staff are going to have to be, just making it up. trying to understand what the Supreme Court meant. We are going to have a red state, blue state approach to water quality. As I mentioned, because of state law and hydrology, it varies differently and drastically throughout the country. One other thing I want to say there is, in some states, we have already seen, even before the Sackett decision and since the Sackett decision, situations where industry is going to lean heavily on the state government and say, now that we have EPA out of our way, now that we have the Clean Water Act out of our way, you're the only thing standing between me and dumping. And it's going to weaken those laws further. In other states, knock on wood, we hope to see a very robust, strong post-Sackett response from state legislatures more concerned with environmental protection. So it's gonna really just amplify the red state, blue state dynamic, unfortunately. In the context of TMDLs, which again are watershed restoration efforts, it really was part of the centerpiece of the Clean Water Act, making sure we are restoring water quality. You're not going to be able to restore water quality if more of the polluters within a watershed are no longer considered point sources of pollution. Folks who would previously have been considered point sources of pollution may no longer be. And if you're not jurisdictional, right? So that means the Clean Water Act can't, the Clean Water Act permits can't be ratcheted down to be more protective in the future because the Clean Water Act no longer applies. So it's going to make TMDLs harder to implement and our restoration goals harder to reach. I think it's also important for people to know one of the many unintended consequences. There will be fewer NEPA and endangered species reviews triggered because oftentimes those are triggered by a 404 wetlands application. Fewer of those means fewer endangered species and NEPA reviews. That's a real big problem as well. So all of you on this webinar, I hope are on the right side of history and wanting to help with the post-Sackett response. So we need to become more familiar, starting with attending this webinar and thinking about your own communities and your own state legislatures. We need to become more familiar with our own state laws. Here in Maryland, most people don't think too much about the Maryland water pollution control laws, but they are equally applicable with the Clean Water Act. We need to become more familiar with them, more familiar with what they mean and what they can do, and more comfortable pushing regulators to use those laws. However, I was giving a presentation to some folks in Pennsylvania earlier, and I said, you guys are in a really good position because Pennsylvania not only has a constitutional right to a healthy environment, which is fairly rare, even more rare than that, they are one of the only states in the entire country that has a public right under state law to enforce against a water pollution violation. Maryland, Virginia, almost every other state doesn't have that, right? So when the Clean Water Act protections went away post-Sackett, so did your right to go to enforce a violation of the Clean Water Act in federal court. And most states do not provide a comparable right to their residents in state court.
So that we had a question come in specifically about that. How does this impact citizen standing? So when we are referring to citizen standing, what we're talking about is an individual's right to sue under the Clean Water Act for violations of that federal law. So what you're saying is that although we have state water law protections in Maryland that still apply to a lot of these waterways that Sackett has taken jurisdiction away from on the federal level. We do not have, as individuals in Maryland, the right to sue. We do not have citizen standing to sue in state court over those water law violations.
Yeah, it's standing, but it's also a cause of action. So here's a good example. Maryland, which has both a really good definition and a really robust regulatory program and state laws for waters of the state, we don't have the ability to go into court to enforce violations. So what does that look like? Well, we have hundreds of facilities around the state of Maryland, for example, that discharge into groundwater. Same in other states too. And that's a water of the state. But if that facility is violating its permit, or they're just, they're polluting, I can't do anything about it. The Clean Water Act does not now and never did cover groundwater discharge permits. Right. So we didn't have a right. We don't have a right to enforce that violation because it's a violation of state law, and the state law does not provide the public the right to enforce. So we're reliant on the regulators to actually do their job, which has been problematic recently. See what else we have here. All right, so I don't want to get too much into this. We already talked about a lot of it, but the sunny outlook is, as I said, that the damage remains in the 404 program and not it doesn't spill over into 402, right? The NIPD's program. That the County of Maui case really helps protect against any problems, because if a discharge reaches just short of a navigable waterway, it's the functional equivalence of a direct discharge, right? So protecting that, if that's protected, if that remains, then it limits some of the damage under the Clean Water Act. The cloudy outlook is Maui's overturned, or the lower courts really seize upon, there's a typo in there, it really seize upon the fact that the definition of water in the United States applies to both programs equally, and they really start to whittle away at the jurisdictional protections of the Clean Water Act writ large, 402 and 404. The dystopian outlook, as I mentioned earlier, is if Thomas and Gorsuch were to attract 3 more votes, we have the end not only of the Clean Water Act as we know it, but the end of most federal environmental laws as we know it. So we really have to just cross our fingers that that doesn't happen in the next few years or decade under the new Roberts Court. All right. I think we should just skip to questions at this point. I mean, I was just going to basically give this as a call to action. So, do what you can in your own states and your own communities to reach out and push your elected leaders to take action. It's the Supreme Court's conservative majority really believes in a federalist approach. And what they wanted to do here was limit federal jurisdiction and put more on the states. And like it or not, it's now incumbent upon us to act in the state venues. So, tell your elected leaders we want to strengthen your wetlands protections, your water pollution control laws, and tell your regulators you want them to do their job. Make sure that, they have the budget to do their job, but then actually have the political will to do it as well. You can blunt the impact of the Sackett decision by just doubling down on the laws we have on the books and making sure they're properly enforced. With that, I'll take any other questions we may have.
So we had a slew come in that we haven't had a chance to get to. And before I give those to you, I just want to let the audience know that our email addresses are up on the screen. Feel free to reach out to us with any questions that we don't get to answer now or that you haven't had a chance to put in the chat. Anyone whose questions are in the chat that we don't get a chance to answer, again, we will email you directly if we have your email address. If you have a legal issue that you need legal advice about, please go to our website, www.chesapeakelegal.org. There's a Get Legal Help button that you can put an intake form into, and someone will be in touch. If you want more educational programming like this, please consider donating. You can find the donate button on our website as well. We want to thank everybody so much for attending today. We know that it's 1 o'clock. We're going to stick around for a few minutes after this to answer some of these questions. But if you have to leave, thank you again so much for attending this afternoon.
And you're going to copy and paste the questions so we don't lose them?
Yes, we have all the questions, so we don't lose them. Yes. All right. Let's see. How did this comes to our point about this being a plurality opinion with no one dissenting. Yeah. How did the Department of Justice so mess up their argument in the case that they lost all of the D-appointed justices? I
have no idea. Dave, you had a theory about it.
Right. So, like everybody, I have to start with a cliche, but bad facts make bad law. So these were not good facts. Sackett was not a good case. Pacific Legal Foundation just waits in the wings for cases like this.
Well, let me just mention too, so the Sacketts are one of the cast of characters, but the Pacific Legal Foundation has been attacking the Clean Water Act since 1977, right? They have a particular disdain for the 404 program, again, under the sort of property rights ideology. It's not so much an industry-driven group as they are property rights, and they really hate the concept of having to get a federal permit to regulate filling in wetlands.
So, just the facts on the ground for this property were that it was an already developed area, though the Sacketts purchased. Now, mind you, the Sacketts own an excavation company. I think a medium-sized one. So they were well aware of the risk they were taking, and they were well aware that where they wanted to build and purchase property was likely a wetland, but it was not a gimme. And so without getting into some of the administrative law aspects, which also were bad facts for EPA, in my opinion, the facts in this matter were perfect to unravel for the Supreme Court, except it was in the Ninth Circuit. And so they lost in the Ninth Circuit, which got them here. And so they split those cases and they ended up ruling on this. And I don't think it was necessarily a big mistake by the Department of Justice. I think it was bad facts in a court that was just sort of salivating over this opportunity to do this, as Evan was talking about.
I will say too, though, in defense, I still don't agree with including the three democratically appointed justices who issued just an absolutely scathing concurrence. It should be a dissent. Kagan's dissent was a brutal takedown of the majority.
Concurrence.
A concurrence.
Okay.
It was a very satisfactory read, but I don't agree with them. I don't see how, personally, just knowing that the prior test was a science-driven test, it was applied by the district court, it was applied by the Ninth Circuit, very smart jurists, it was science-based. There was a giant wetland with a stream running into a lake. To me, that is exactly what the Clean Water Act was designed to protect. Its purpose was to, and then walk through that, the impact of that wetland on the lake. They said it was regulating base flow, reducing pollution. Remember, wetlands and ephemeral headwater streams are one of our major pollution sinks in our ecosystem. They process nutrients and other pollutants. If you fill them in, you lose that pollution trapping capacity and the lake gets polluted. I think they did their job, and I think they reached the right decision, and it baffles me why it was a 9-0 opinion. There's probably some horse trading or wrangling.
Right, that's all I read was an assumption that it was horse trading, that Kagan was maybe trying to pull Amy Coney Barrett toward them by, ruling by voting for it, but having a more modest and moderate opinion. And, with the irony is that there's no question, right, that if they were to put some sort of discharge there, that Maui would cover that discharge.
Exactly.
It's a no-brainer.
And without getting too in the weeds, but we're past our hour, so let's get a little weedy. What really bugs me too is that Roberts, as I mentioned, was in the majority for County of Maui, which was a very purpose-focused, science-driven decision.
Right.
You did the opposite here. And
just so folks know, County of Maui identified discharges that are, as Evan mentioned before, the functional equivalent, and it went through, as Evan mentioned, it was science-driven, so it went through a number of common sense factors that would link hydrologically a discharge to a water of the United States. And some of those factors, involve this sort of intensity, concentration, distance, time, et cetera, things that, any common sense jurist would contemplate. And here it's interesting that they went so far from that.
And it would be one thing if it was 6-3 the other way. But remember, Kagan joined the 3 democratically appointed justices. Roberts could have very easily taken this case the other direction by just joining Kavanaugh. And there's nothing obvious to me about why he wouldn't, right? He and Kavanaugh could have very easily just made this the opposite. And they could have limited the decision too. It was a fairly expansive decision. So it boggles my mind how it ended up the way it did.
I wanted to talk real quickly about the state laws, particularly the Bay State. So it's actually, ironically, it's a great sort of hypothetical, it's not hypothetical anymore, situation as to how state laws could be set up to see how this could unfold, because Pennsylvania has very strong state water pollution control laws and citizen intervention rights almost across the board. Maryland has very strong water pollution control laws, but without the rights. And Virginia has relatively weaker water pollution control laws and no citizen intervention. And so when we talk about the difficulties, as Evan mentioned, when there's no ability for neighbors or citizen groups or advocacy groups to bring that, obviously they're out of the game if it's not now under federal jurisdiction, but also, as you can imagine, not all departments of the environment, whatever they may be called, Department of Environmental Quality or Department of Environmental Protection, they're not all built the same. They don't all have the same resources. And so it's not just that we lose access, it's that they lose the pressure, they lose political cover. If they have 1,000 cases, how many of those do you think they're going to take up without any real citizen pressure that has tools in the toolbox, other than saying they're not doing their job? And I think that's the part that when Evan made his call to arms, I think that's where we really have to keep our eye on the ball.
Other questions that you wanted to pose? We're a week so far past time and we should.
I think it's 1:07. We should let our audience go. I do have some outstanding questions here, but we'll make sure to reach out via email. I want to thank everybody again for attending. Thank you both for such an informative and interesting presentation. Have a wonderful afternoon, everyone. Thank you again.